Mesdames et messieurs,
ladies and gentlemen, dear colleagues, dear friends, the early birds, people aren't all early risers, and at the Academy we start the summer courses and the winter courses a little later in the mornings, and in fact we only have 3 lectures per morning. Here this colloquium is far richer, and for a good reason. These are scientific events where a lot needs to be said about major issues which are both relevant and topical. And these relevant and topical issues, well, the Academy usually submits these to the Research and Study Center, which in fact brings together young researchers under the direction of professors, experienced lecturers working on a theme which inevitably leads on to sub-themes which are also very topical and relevant. And Professor Waibel, who's here, I thank him for his presence, has accepted the difficult task a few years ago. He'll tell us when. It was already way back, the task of working on the legal implications of global financial crises. And I believe that we have all gone through very difficult periods, and where the financial crisis, which started in one country, then spread and led to human and economic crisis. And does the law have anything to say about these financial crises? And when we're not specialists in the field of finance, we don't, in fact, hear much about the role of international law. And yet our young researchers, under the direction of Professor Waibel, have produced this book, which I believe is crucial, especially when you think that we might be facing future financial crises for various reasons. So today we shall be addressing all these issues, again, around this book. And for that purpose, we have called on the professors who are in charge of this theme, and we have asked them to call on young researchers, sometimes it's not easy, to work with them and who were involved in their work, this research work. So we're now going to hand over to Professor Waibel, and we have a guest, Professor Geneviève Baivot, who is also a major specialist in economic international issues. You have the floor.
Good morning, everyone. It's a great honor to be invited to take part in the centenary celebration and the symposium. Thank you to the Academy, the Curatorium, President Daudet, and the Secretary General for this splendid and fitting event to celebrate the Academy's first 100 years. With me on the podium are Professor Annamaria Viterbo and Professor Geneviève Bastide-Bourdeau. After some introductory remarks, they will intervene in this order, with Professor Viterbo focusing on sovereign debt, and Professor Bastide-Bourdeau, in keeping with the Secretary General's call yesterday, focusing on the future of global finance and international law. Merci à vous tous pour être là si tôt. Nous espérons aussi avoir du temps pour quelques questions à la fin. Should and can global finance be submitted to international law? That was the question that was put to us. At first sight, international financial law is thriving. Lawyers have been essential drivers of rapid growth of global financial markets over the last several decades. They were innovators, drafting the legal documentation of Eurobonds, collateralized debt obligations, and credit default swaps. The same applies to the purchases of securities abroad and cross-border mergers and acquisitions. But public international lawyers have, for the most part, been observers rather than in the driving seat, rather than active participants in these important developments in international finance over the last several decades. The question has two parts. The second part of the question is the easier part. Pretty much anything can be submitted to international law if states so choose, but states have decided, at least for the time being, not to submit global finance, for the most part, to international law. And that may appear surprising, given the developments I've just mentioned. Yet it is where we currently are. International law, at least public international law, has yet to become part of the plumbing of the international financial system. And there is some point of contrast with international monetary law, to which Professor Bourdeau, for example, has contributed, as well as Professor Viterbo. International monetary law, there we have an important role for public international law since at least 1944. Though that doesn't necessarily mean that international monetary law is part of the mainstream in public international law. As James Crawford put it, commenting on the life of Francis Alexander Mann, a notable scholar in this area, international monetary law, according to James Crawford, is a specific topic of international law without wider resonance. Now, the second and more challenging part of the question is, should global finance be submitted to international law? Again, the response of states so far has been a resounding no. But the wall of separation between global finance and international law is no longer hermetically sealed. Leaving aside international law for a moment, since at least the East Asian financial crisis of 1998, there has also been a sustained shift from public to private ordering at the expense of public regulation in the area of finance. I want to do two things now before handing over to Professor Viterbo. Very briefly survey the contributions in the volume that I had the honor of editing for the Academy, and then provide some tentative explanation for why states have, for the time being, chosen not to subject global finance to international law. International financial law is an amorphous and ill-defined field. The volume that the Academy published was focused on international financial law rather than international monetary law, at least for the most part. We faced two main challenges in researching this volume. The field of international financial law is vast, and it is also a moving target, particularly after the global financial crisis as we convened in 2013. The main task, as we understood it, was to take stock of international finance after the global financial crisis that started in 2007. And this is reflected in the title of the volume, Legal Implications of Global Financial Crisis, les implications juridiques des crises financières de caractère mondial. The participants tackled challenging topics with the collaborative spirit that Suzanne Zhu captured so well in her remarks on Wednesday. There are 14 chapters in the volume, and in keeping with the bilingual tradition of the Academy, 7 are in French and 7 are in English. Other than sovereign debt, to which several chapters are devoted, chapters tackle questions such as financial services liberalization, litigation and arbitration related to financial services, the role of credit rating agencies in their regulation, and deposit insurance. The report of the Director of Studies provides some broader context to the chapters. The causes and consequences of the global financial crisis, changes in the international monetary and financial system since 1944, and it argues that the growth of international financial markets has outpaced the development of international financial law over several decades. And then also examines the backlash against the first era of global capital that lasted from around 1870 to the outbreak of World War I, and the second era of global capital and the current backlash against it. Now, turning to the second part of my introductory remarks, why have states been reluctant to submit global finance to public international law? I think there are at least two related reasons for that reluctance, for why public international law has had limited purchase in the area of international finance thus far. The first is uncertainty, and the second is the desire of states to preserve policy space, particularly in financial crises. Now, uncertainty, of course, isn't something that is unique to international finance. But I think there is good reason to believe that international finance is characterized by more uncertainty than other areas of international economic law, at least. Trade, international investment, and international tax law. States and policymakers and scholars do not agree on what measures are necessary in advance to respond to financial crisis. And this lack of consensus means that it has been very difficult to come up with rules. And states have, as a result, been very reluctant to agree to binding rules of international law in this area. Policymakers simply do not know what package of measures will help stabilize an economy. Think of the recent collapse of Silicon Valley Bank in the United States, the 16th largest bank in the United States, and the shotgun marriage between the two largest Swiss banks, Credit Suisse and UBS. Economists have long drawn a distinction between risk and uncertainty. Risk, they say, is measurable uncertainty. We know the probability and we know what the consequences may be. But this is very different in cases of uncertainty. As Jacqueline Peel explains in her excellent book, Science and Risk Regulation in International Law. Policymakers have no idea what the objective probability distribution is. They simply do not know the odds. So uncertainty is non-quantifiable. The probability of the occurrence of adverse events is unknown. And this, I think, has at least been seen by policymakers to be a major feature of international finance. As the famous British economist John Maynard Keynes put it, we simply do not know. And this uncertainty has produced genuine disagreements among states about what needs to be done. This, of course, has similarity with other areas of international affairs. When the World Health Organization declared the SARS-CoV virus a public health emergency of international concerns, decision makers knew very little about this novel virus and the consequences. They did not know. They were faced with a situation of uncertainty about the future trajectory and how many deaths this new virus would cause. So just like epidemic models were full of uncertainty at the time, international finance is characterized by this uncertainty too. And I think this uncertainty characterizes recurrent features of international finance today. It explains the pervasiveness of soft law, the fragmentation into different regulatory bodies, many of whom only produce recommendations and soft law, thinking of the G20, the Financial Stability Board in Basel, which is subject to a dedicated chapter by Sara De Vito in the volume, or the Basel Committee. There's a prevalence of networks and peer review rather than rules. discretion rather than rules is the order of the day. We have informal networks of regulators that cooperate with one another, and peer review substitutes for formal dispute settlement. Now, this may in part be in keeping with a broader trend that we have seen in international law in recent decades, the flight from international organizations, as Eyal Benvenisti called it in his Hague lectures in 2013, has been particularly acute in the area of international finance. Financial regulators, much more so than treaty drafters, as President Donahue referred to it yesterday, like constructive ambiguity. They like discretion rather than rules when it comes to responding to crisis. That means they like non-binding instruments rather than formally binding treaties. Now, there are, of course, debates about the merits and demerits of this approach. But it is what we have for the time being in the area of international finance. States have, over the last 4 or 5 decades or so, been reluctant to commit to any particular set of tools in advance. Matters are simpler in the area of trade or investments. For a long time, for several decades, states have broadly agreed what it takes to liberalize trade or to protect investors. But as we've heard yesterday, that in part is also changing. So policymakers have preferred discretion over rules to safeguard their regulatory autonomy. But especially after major financial crises, there is often a need for accountability. A lot of people get hurt. And what we have seen, particularly after the global financial crisis, is that rather than regulators, others have stepped into this gap. As Pierre Verdier argues in his book, Global Banks on Trial, US prosecutors in particular have mounted a sustained enforcement campaign against global banks for benchmark manipulations, tax evasion, and sanction violations. They became, de facto, the regulators of systemically important banks. Tens of billions of dollars in fines were paid, and these banks were subject, de facto, to US law, US financial regulations in their operations worldwide. There is a debate whether this is a useful development for international finance, whether it might provide a stepping stone towards more multilateral cooperation, or whether this form of unilateralism has major downside. One final feature of international finance is that for the most part in recent decades, we have seen little formal dispute settlement, and that is linked to this prevalence of networks and peer review. We have very few examples of international dispute settlement between states concerning financial disputes. And one reason for this, as Anne Hertigan explores in her chapter on financial services liberalization, is that the prudential carve-out in the General Agreement on Trade in Services has been effective in keeping disputes out of WTO dispute settlement. But one trend that we can observe in recent decades is that more and more private actors, creditors, and others hurt by crisis resolution measures, think of regulators closing down a bank over a weekend, they suffer losses, and they turn not just to domestic courts, which is often difficult because of wide-ranging domestic immunity, but they turn to international fora as well. human rights courts, the European Human Rights Court in particular, but also an increasingly investor-state arbitration. And that has had the effect of transforming or making some of this area of international finance subject to harder rules in practice. And it conflicts with the traditional approach of financial regulators, which was not to resort to litigation, to maintain good relationships with one another, also to maintain secrecy. And there is perhaps one feature of international finance that means that dispute settlement, formal dispute settlement, is ill-suited to what financial regulators want to achieve, and that is the need for speed. A solution may need to be found for how, for Credit Suisse, for example, in the space of 36 hours, that is, before financial markets open again in Asia. And that, too, perhaps explains why interstate litigation before international fora has thus far been a rare phenomenon in the area of international finance. We see, at the same time as mentioned, a rise of private-to-state litigation, including before international fora. And that means that investors and others hurt by resolution decisions and financial regulation more broadly may be better protected than regulators. And one important question is whether that should continue to be the case going forward. Does this not end up privileging private over public interests? Thank you very much for your kind attention, and I now hand over to Professor Viterbo.
Excellencies, dear colleagues and friends, it is an honor for me to be here today, and I'm really grateful for this kind invitation for the Academy. 10 years ago, we met under the auspices of the Hague Center for Studies and Research to analyze the legal consequences of the global financial crisis and appraise the reforms that had resulted from it. Today, in the aftermath of the pandemic, we meet again to celebrate the Hague centenary and assess whether the current international financial architecture is apt to tackle pressing global challenges, ensuring both financial stability and sustainable development. Unfortunately, our assessment is not a positive one. As the UN Secretary General Antonio Guterres recently affirmed while briefing the General Assembly for the priorities for 2023, the global financial architecture is still at the heart of the problem, and it needs a radical transformation. These are indeed difficult times. Our world is facing a polycrisis that threatens the achievement of sustainable development goals. Adding to the COVID-19 pandemic and the climate crisis, adding to the Russian aggression on Ukraine and new geopolitical tensions, the surge in inflation and tight financial conditions have led to a global growth slowdown and have intensified the debt crisis that many emerging and developing countries are facing. In this scenario, many voices are calling for a new Bretton Woods moment, wherein the international financial institutions of the 20th century will undergo sweeping reforms to promote a more prosperous, just, and sustainable world economic order. We certainly need more legitimate and accountable international financial institutions. We need to reinforce the set of institutions and mechanisms that form the so-called global financial safety net to help countries anticipate and mitigate financial instability in a manner that accelerates green and inclusive prosperity. We need not only financial stability, we need social and environmental sustainability. And for this purpose, we need to scale up financial development finance. But most importantly, and this is the topic I'm going to mainly focus on, we need a new approach to sovereign debt restructuring. So far, however, on all these issues, only timid progress has been made in the last decade. I will just mention a few examples before turning on sovereign debt issues, starting from the Bretton Woods institutions. The IMF, for instance, after having indeed responded to the pandemic with unprecedented speed and magnitude of financial assistance, is currently struggling to conclude its 16th general review of quotas. The reason lies in the fact that the expected rebalancing in favor of emerging and developing countries will reduce the voting power of G7 members. But such a rebalancing will also have important, I would say, positive implications for the IMF instruments and policies, in particular on how to integrate climate change and other environmental challenges in the fund's activities. Discussions are being held also on how to reform and strengthen the World Bank and multilateral development banks, MDBs, which need a sizable capital increase to keep providing critical lending to developing countries. Regrettably, the historic issuance of $650 billion in special drawing rights, for those who know a little bit more about the IMF, which was made very late in the crisis, in August 2021, went mostly to the benefit of wealthy economies, as mandated by the treaty on the basis of the quota-based distribution criterion. And the promises made by G20 to rechannel their unused special drawing rights towards multilateral development banks are yet to materialize. In addition, the IMF and the World Bank infamous conditionality is increasingly criticized, and competing institutions are appearing on the scene, like the new development bank, where BRICS, Brazil, Russia, India, China, South Africa, have equal shareholding power and no conditionality, at least in traditional neoliberal terms, is attached to loans. Donor fatigue is at the heart of debates on financing for development, as experts estimate that between now and 2030, low and middle income countries need to mobilize more than $2 trillion per year to meet their development and climate goals. Yet, progress on sustainable development goals is nowhere close to being on track. And worse, on key targets like poverty reduction, too many countries are regressing. But the most glaring and worrying gap in the international financial architecture is the absence of a sovereign debt restructuring mechanism. And the rest of this presentation is the topic on which I'm going to focus, which was also the topic I addressed in the volume we are presenting. I will first describe the critical juncture the world is facing. Next, I will briefly summarize the shortcomings of the current legal framework, and then I will conclude by underlining the crucial role international law has to play. There is no doubt we are spiraling towards a new debt crisis. Since 2008, the debt level and service payments of developing states have more than doubled. The IMF and the UNDP estimate that nowadays 69 countries are either at high risk of debt distress or have already defaulted. That is 1/3 of middle-income countries and nearly 2/3 of low-income countries. These states, which represent 20% of the world's population, are allocating an extremely high portion of their government revenues and foreign reserves to service their debt, while having at the same time enormous spending needs. We all know how unsustainable debt service payments slow growth and block progress on education, health, and climate action. For highly indebted poor countries, this means sliding towards a new lost decade, like in the 80s, or even worse, I would say. Urgent action is needed, but the sovereign debt restructuring mechanism, legal framework, is not fit for purpose. It is common knowledge that even if sovereign defaults are a structural phenomenon typical of the global economy, almost 150 in the last century, no comprehensive mechanism similar to domestic bankruptcy laws has ever been established at the international level for states. Therefore, when sovereign debt restructuring becomes necessary and unavoidable, what happens is that different categories of creditors are grouped together. And for each category, official bilateral creditors, banks, commercial banks, sovereign bondholders, for each category, debt is treated using a dedicated vehicle. In practice, the form of the negotiations is set by the legal nature of the debt instruments being restructured. In the past, sovereign debtors used to renegotiate mainly with two creditor groups, with commercial banks, especially in the 70s, through the creation of ad hoc creditor committees, and with official bilateral creditors through the so-called Paris Club, which is today still an informal group of only 22 creditor countries, mainly all the G7 members and mainly all the OECD members, the functioning of which is not regulated by a treaty, so it's not an international organization, and only group together creditor countries, debtor countries, never managed to have a unified voice. Things, however, for that time have greatly changed. Over the last decade, the creditor base of developing countries has grown more diverse. Sovereign bondholders have become the largest creditor group, even for emerging and developing countries, and they on average hold 27% of their outstanding debt. It's much, it's a lot. They are followed by multilateral development banks, on average 26%, and China, which is not a member of the Paris Club, and China holds on average 10% of their outstanding debt. Each of these three creditor groups raises various issues, and I will briefly address some of them. First, the restructuring of sovereign bonds is entirely based on a contractual approach, which entails the introduction of ever more modern contractual provisions, like the famous collective action clauses in the bond documentation. However, half of the international sovereign bonds issued by emerging and developing countries do not incorporate these modern provisions and remain therefore at risk of holdout tactics. Second, multilateral loans disbursed by the IMF, the World Bank, and MDBs are usually excluded from the restructuring process. In fact, because of the global public good functions these international organizations perform, they are considered to deserve preferential creditor status, and even if there is no treaty or customary law rule on that matter. So far, only once, at the end of the 90s, the IMF and the World Bank accepted to cancel the entire debt they were owed by a small group of 36, mostly African, heavily indebted poor countries. That was the name of the initiative, heavily indebted poor countries, HIPIC. Nowadays, however, many experts claim, and interestingly so also China, so not only human rights expert, the independent expert on foreign debt, for instance, but also some bilateral, in particular China, they claim that these multilaterals should take a haircut, should accept to cancel the debt they are owed, together with the other bilateral official creditors and commercial creditors, banks. Let's turn to China and the other new bilateral creditors, lenders, this is a big mistake. They are not members of the Paris Club, and they do not seem interested in joining the Paris Club. Therefore, there is still no streamlined process to renegotiate with these bilateral creditors. Among them, China in particular deserves special attention. Recent research shows that developing countries are much more indebted to China than to the IMF, the World Bank, and multilateral development banks, all combined together. More importantly, China has a very different approach to lending and debt relief. Chinese debt contracts have very distinctive features. They are subject to strict confidentiality. It's very difficult to know how much countries are indebted towards China. They include collateral clauses that secure repayment through commodity exports proceedings, oil, but also natural resources. And they also come with a different type of conditionality. For example, related to the promises to keep diplomatic isolation of Taiwan, both exchanges in international fora, the use of Chinese workforce. But there are also other challenges. For instance, it has become harder to distinguish between official and commercial lending, especially for what concerns debt contracted by state-owned enterprises. In sum, the increased fragmentation of the creditor landscape, which I've just tried to describe, has made the process so complex that not even the G20, at the peak of the COVID-19 crisis, was able to agree on a permanent and comprehensive sovereign debt restructuring mechanism. In fact, the initiative most recently put in place by the G20 together with the Paris Club, the so-called common framework, falls short on three counts. First, only low-income countries are eligible for debt relief under this common framework. Small island developing states, most vulnerable, climate-vulnerable countries, prone to be highly indebted, and middle-income countries do not qualify, even when they are already in default, like Sri Lanka and Suriname, which are currently discussing their default. Secondly, the common framework only covers bilateral debt. Even if China is on board, this is a novelty, important novelty, together with the Paris Club, it only covers bilateral debt. That means that debt relief provided under this initiative is being diverted to paying private creditors and also multilaterals. Third, the climate and development goals of debtor countries are not properly taken into account, and this despite the fact that the G20 members are signatories of both the Sustainable Development Goals and the Paris Agreement. They didn't take this into account in framing the new mechanism. So to address the forthcoming debt crisis, we need to go beyond what we have, the common framework. But how? Should we adopt a statutory approach based upon international law, a treaty-based approach? If 20 years ago, at the beginning of the Argentinian crisis, the proposal to establish a treaty-based mechanism under the umbrella of the International Monetary Fund was considered overly ambitious, nowadays such a solution seems completely out of reach because of renewed geopolitical tension. What we have is a new table of discussion. It's called Global Sovereign Debt Roundtable, which for once is gathering all the key stakeholders, the financial institution, private sector, official bilateral creditors, and debtors. Is convening, but mainly is discussing only incremental reforms, for example, on increased transparency and information sharing. And it may be true that we only have time for a very pragmatic approach. However, the prevailing contractual and soft law solutions that market operators find so attractive are inadequate to address in a comprehensive, fair, and sustainable manner the shortcomings of the current legal framework. The public sector perspective brought by international organizations, or should I say the public interest perspective, maybe, in the broader meaning we discussed yesterday, brought by the IMF, the World Bank, and even by the United Nations, in a debate which is mostly led by private parties, remain crucial, and I contend it should be broadened to better link the provision of debt relief to the protection of human rights and the achievement of the Sustainable Development Goals. We can think on different tools that the international organizations have at their disposal. Conducting human rights impact assessment, integrating climate change vulnerability in the debt sustainability analysis made by the IMF and the World Bank. We can think of a different kind of conditionality, a green and social conditionality, even if the tool remains problematic for many countries. We can think at debt for nature swaps managed by the World Bank, and so on. In conclusion, I truly believe that in the context of sovereign debt restructuring, international law, mostly through the law of international organization, but not only, is the only mean we have to better balance financial interest with the necessity to achieve climate and development goals for the sake of the present and future generation. But as Michael was saying before, we have the tools. The question is there enough political will? Thank you.
Je ne veux pas.
Thank you very much. I don't want to prolong this presentation on current financial issues unduly, but allow me to make two comments. First of all, to say that in addition to the book directed by Michael Waibel on the debt crisis, in the collected courses you will find book 404, where you'll find an excellent course by Jean-Marc Sorel on international law and financial questions, and it is noteworthy that it presents exactly the same diagnosis as the one just described by Michael Waibel, namely that states have stopped regulating international finance, and thereby they have indirectly lost control over their own currencies. And I don't want to belabor that point, but to finish, may I just remind you that the very fast development of international finance, of course, is connected to information technology, and that this now gives us offers us new perspectives, very worrisome indeed, and are creating bitcoins, etc., which in fact came about after the 2008 crisis, where people lost trust in banks and regulatory authorities, which had in fact disappeared. And this is a claim made by private players, namely that they wish to create a payment system which would no longer come under the control of states and, needless to say, of the central banks, and which would allow for more fluidity in payments. This, of course, is a system. I'm not going to describe it now. I won't dwell on that. But when we think about future years, the presence of electronic or virtual currencies is something which gives cause for concern. So we're starting to see reactions. The Bank for International Settlements has asked itself whether we can draw certain conclusions from these forms of payments, which of course are quite complicated, but certain states, in fact, have decided outright to prohibit this, such as China. Other countries are trying to see what needs to be done about these cryptocurrencies or crypto assets. But in any event, this is an issue which might have to be considered by the research study in the center in the future.
So to both of you for your remarks. I'm afraid I don't think we have time for questions now. The proceedings now bifurcate. We will have a session in this room that starts at 10 o'clock on applicable law, and then another parallel session on international inspections in the seminar room. We're all happy to take questions one-on-one outside. Thank you very much for being here. And if you're interested in the legal implications of global financial crisis, the volume is on display outside, and here's a copy of that book too. But no doubt in 20 or 30 years' time, the time will have come to again assess where we are in crisis resolution. But I think we've painted a picture that's not entirely hopeful about the future. As Professor Viterbo said, the tools are there, and the tools have been there for a long time, but particularly in the area of sovereign debt, but also in other areas, we simply haven't managed to achieve any durable progress to increase the level of international cooperation. Thank you.
Un grand merci pour cette...
Thank you very much for having described.
On a bien compris que si l'on voulait la réguler, on pourrait peut-être...
So we understand that the uncertainty is sought, in fact. It's not an inevitable fact, but certainly we will be able to discuss this around a coffee. Now, we now have two parallel sessions. We had too many issues to, in fact, deal with all of them in one single panel. We have a panel on the law applicable to international arbitration, which will be starting here in this very room at 10 a.m. And I think that we will be able to prolong this somewhat, because what I suggest, in fact, what I'm imposing in reality, is that the reports Professor Waibel will be coming back. Reports on sessions 1, 2, and 3 in plenary. We want to have some brief conclusions, because here, in fact, we dealt with this at length, but we want to have some very brief conclusions and answers to the questions raised. And we'll be looking at this not at 10:50, but 11:10. So that means that we will be a little bit more comfortable in the next panel. We'll be able to hear more questions. So I think we can now have a short break. And that will allow you to choose the room you want to go to. The question of the law applicable to international arbitration is being dealt with here. And upstairs, you will be able to attend the panel addressing the issue, what can we expect from international inspections? Thank you.